Welcome to Inside IR, a podcast series by Herbert Smith Freehills that explores the latest developments in Australian industrial relations law and practice. Hello and welcome to Inside IR, the Australian Industrial Relations podcast, the series that arms HR, IR and legal professionals with the latest industrial relations thinking. My name is Rowan Doyle. I'm a partner in the industrial relations practice at Herbert Smith Freehills, and I'm excited to be joined today on our 25th episode of Inside IR by Senior Associate Mitchell Brennan. Welcome, Mitch.
Thank you, Rowan. Thanks for having me.
It's a pleasure to have you on the show, and it is we've made it to our quarter century here on Inside IR. It's a very great effort, if I may say so myself. But a big thank you, importantly, to all our listeners and watchers for making it such a huge success, and to all those that work on the podcast behind the scenes. It's been a great experience so far, and such a great success, in fact, that we've been spending the summer working on two new spin-off podcast series, Inside Employment and Inside Safety. So tell all your friends, HR practitioners, safety practitioners, look out for those episodes landing in your inboxes very soon. It's worth tuning into those. But first, back to industrial relations. We've got a very important topic today, one that's close to your heart, Mitchell. We're calling today's episode Clear and Unambiguous EAs, a pipe dream or a necessity. What do you think about that title, Mitch?
Well, I hope no one has the takeaway that there's anything futile or far-fetched about striving for clarity and certainty in enterprise bargaining terms.
That is very much the aim. And Mitchell, you're very experienced in the world of enterprise agreements. I don't think there's an industry in which you haven't read countless enterprise agreements. And I often walk past your office to see you reading through one, but often with a furrowed brow. Why is that, Mitch?
I always knew I had a terrible poker face, Rowan. Thanks for confirming that. I guess that there's a few things that contribute to the increasing wrinkles on my forehead. As lawyers, we are tasked with advising our clients on the correct interpretation of enterprise agreements, but determining what the Fair Work Commission or a court might determine to be the correct interpretation is rarely a straightforward exercise. The ordinary meaning of the words used in enterprise agreements often lead to extraordinary complexity and uncertainty, where the words can fairly mean different things to different people reading the same document. Enterprise agreements are also often a product of their history, containing a patchwork of historical artefacts from years, often decades, of enterprise bargaining. And the current custodians of these instruments, our clients and our instructors, often have an incomplete understanding or picture about the development of those terms and why they've developed along the path that they have. There's also an apparent desire at times, often on the other side of the bargaining table, to set terms and conditions in stone. This includes grandfathering of terms, for example, and also the express incorporation of modern award and pre-reform awards as enforceable terms of the operative enterprise agreement. And the latter often causes particular headaches when determining whether there is in fact a direct or indirect inconsistency between competing terms derived from the same instrument.
So lots of reasons for a furrowed brow in trying to read these things. That all makes sense. But what it does remind me of is the great decision of Justice Madgwick in Cucks and CSR from back in 1996. And it's such a great quote. In fact, I'll read it. And it gives some guidance on how to go about interpreting awards, but it's also often relied upon in the task of interpreting enterprise agreements. And it says, "It is trite that narrow or pedantic approaches to the interpretation of an award are misplaced. The search is for the meaning intended by the framers of the document, bearing in mind that such framers were likely of a practical bent of mind. They may well have been more concerned with expressing an intention in ways likely to have been understood in the context of the relevant industry and industrial relations environment than with legal niceties or jargon. Thus, for example, it's justifiable to read the award to give effect to its evident purposes, having regard to such context, despite mere inconsistencies or infelicities of expression which might tend to some other reading. And meanings which avoid inconvenience or injustice may reasonably be strained for. For reasons such as these, expressions which have been held in the case of other instruments to have been used to mean particular things may sensibly and properly be held to mean something else in the document at hand. Now, that's a quote that's referred to in just about every enterprise agreement interpretation case these days. And what the judge is referring to, His Honour was of course acknowledging that the drafters of enterprise agreements, particularly back in the 90s when this case was determined, were often not legally trained. They were the site manager or the industrial relations manager or the union official, and the agreements needed to be read with that in mind. But Mitch, what that quote does, it really highlights a bit of a problem, doesn't it? Because what it stands for is that enterprise agreements might not actually mean what they say. Now, of course, as you rightly point out, the starting point is the words read in context. Of course, that's necessarily the starting point. But the context is relevant, and that context might not be apparent to the reader of the instrument. That's a bit of a problem. And as His Honour points out as well, precedent cannot necessarily be relied on if it's dealing with other instruments, other contexts, other workplaces, even if they're interpreting the same terms. That precedent might have limited guidance. Now, all of that, I think, is further justification for your furrowed brow, Mitchell, in reviewing these instruments. But this has always been a problem. So why are we talking about this now, Mitch?
I think at the time that CUX was decided, we had a industrial relations system that placed an emphasis on the conciliation and arbitration of disputes to determine how terms and conditions were going to apply. You could argue that the stakes are much higher now. We have new criminal offences for criminal wage and superannuation underpayments and higher civil penalties, and a lowering of the bar for serious contraventions associated with an underpayment, which all commenced on the 1st of January of this year. We also have an increased regulatory focus on prosecuting wage non-compliance and underpayment of wages. Underpayments and wage compliance is, of course, something that's been front of mind for most HR, IR, P&C and legal functions for a number of years. And what experience tells us is that the focus for most organisations is working out how it can live with its industrial instruments, which are often saddled with complexity and uncertainty, and not looking to how they might address that complexity and uncertainty in the future.
Yeah, well, I agree. The stakes are certainly higher now for all those reasons, and I'd probably add to that list reputational consequences as well. I mean, there's some really adverse reputational consequences that go with getting compliance wrong and underpaying people in accordance with the instruments that apply to them. And in fact, we often get asked, Mitch, this is another topic close to your heart, to assist in drafting or vetting payrolls for employers to feed into payroll systems. And it's in going through that painstaking task that you often unearth inconsistencies and difficulties in enterprise agreements. They might, for example, set out a clear entitlement in one circumstance, like a pay rate that applies on weekdays, but say nothing about what happens in another circumstance, pay rates on weekends. Or you might also get clauses that are just simply directly inconsistent. You can't easily work through what the intention was in terms of a particular entitlement. So these issues, I think, are very much getting more attention, I guess, than they used to, Mitch, for all the reasons that you mentioned. But the reality is long enterprise agreements and enterprise agreements with complicated and ambiguous terms cost money. They cost money in a whole range of different aspects. They cost HR and management time in reading them and working out what to do with them. They cost legal fees in getting external advice on what compliance looks like. They cost fees and management time in dealing with disputes that ensue when there's different views about how certain conditions are to operate. You then have potential regulatory proceedings that involve the risk of 6 years' worth of back pay, penalties, interest, and the like. Now, I think very few people, Mitch, have you seen people actually quantify all of this in terms of the cost? I mean, I haven't seen too much of that.
Not from the outset of, from the outset of enterprise bargaining or anything like that, as you've touched on in previous episodes of the podcast. There's often little consideration of the value of a dollar when entering enterprise bargaining, and I think that the value of a dollar, as I often put it, needs to incorporate all of these on costs, particularly of compliance, and sort of satisfying yourself that what you're paying people is what your industrial instruments are saying that you should.
Yeah, and in assessing that cost, you've got to factor in also the time and risk that comes with uncertainty. So I think because of all of those things, there's a greater realisation that there's a lot to be gained in having shorter, more efficient, clearer instruments. And for that reason, we're seeing a lot more focus being given to bargaining, and in some cases more involvement of in-house legal or external legal practitioners to sort of help with that process. But what is clear, negotiating a simple, clear, short agreement, particularly where your starting point is far from that, is not an easy process. And that sort of brings us back to our title. We chose the word pipe dream quite deliberately. A pipe dream means an unattainable or fanciful hope or scheme, Mitchell. So a clear enterprise agreement's an unattainable, fanciful hope or scheme, do you think?
Not at all. But it's not going to be easy.
That's good to hear. So look, with that context, there's three things that we want to cover on today's podcast. I think the first is Mitchell's going to give us a handy refresher on the risks. What are the potential consequences of having long, complex, unclear, ambiguous enterprise agreements that are difficult to comply with? And what's the current regulatory landscape? Second, we'll move on to the source of the problem. We'll unpack that a bit more. Why are some enterprise agreements saddling some employers with a relatively large non-compliance risk? And then finally, having admired the problem a little bit, we'll turn to some solutions. Mitchell's promised to explain how we can negotiate some changes to our instruments, make them clearer, make them shorter, make them simpler. How might we be able to encourage unions and employees to join employers on that very well-reasoned journey to simplicity? And what are the options where perhaps that isn't achievable? So that introduction, Mitch, let's get straight into it. The first question, why is this important? Why do the risks of complicated and unclear enterprise agreements, why have they escalated of recent times?
Well, the big ticket reason, as I see it, is the introduction of a criminal offence for intentional underpayment of wages or entitlements. Under these offences, an employer may commit a criminal offence where they were required to pay an amount to an employee, such as wages or paid leave entitlements, or required to pay an amount on behalf of the employee for their benefits, such as superannuation or a salary sacrificing arrangement, and have intentionally done something that results in those amounts not being paid to or on behalf of the employee when they were due and payable. There are some limited exceptions that apply to state-referred businesses who are not constitutionally covered businesses, but these businesses may nevertheless be covered by state and territory-based wage theft laws. The criminal offence is punishable on conviction with a fine for body corporates and a term of imprisonment for individuals of not more than 10 years, or a fine for individuals where the courts can determine the underpayment amount. The maximum fine that a court can order is the greater of 3 times the underpayment, or $1.35 million for an individual, or $8.25 million for a body corporate where that amounts can't be ascertained by the court. So
this is criminal liability, new criminal liability as of 1 January 2025, which of course only applies where there's an element of intent to deprive the individuals from payment amounts they're entitled to. But there are also some increased penalties in the civil jurisdiction, Mitch.
That's right. The civil remedy provisions for many contraventions of the Fair Work Act have also been increased to at least 5 times their former penalty value, and the bar has also been lowered for what constitutes a serious contravention to include an element of recklessness. And a person is reckless if they are aware of a substantial risk that the contravention would occur, and it is unjustifiable to take the risk having regard to the circumstances known to that person.
Yeah.
These new criminal offences and higher civil penalties for underpayment contraventions means that it's pretty risky for employers to turn a blind eye to enterprise agreement complexity and ambiguity, given the significance of the consequences that might flow if an employer is found not to have complied with pay obligations.
And we also have an active regulator in this space, of course. I mean, the Fair Work Ombudsman is very active in looking at employer wage compliance with their instruments. So definitely worth having a close look at. But there's one additional risk I'd probably add to that list, Mitch, and that's potentially not getting your enterprise agreement approved in bargaining. I mean, we know that there's a much greater focus these days on the genuinely agreed requirement. The Fair Work Commission has to be satisfied in approving an EA that's been voted up by employees, that employees have genuinely agreed to the instrument. And one element of that assessment is have employers taken all reasonable steps to explain the terms of the new EA and their effect. Now, if the employer can't work out what the EA means, or there's significant complexity in its terms, then that's of course a much higher threshold to meet. And we know the Fair Work Commission's taking a much closer look at these requirements. And so I think increasingly we're going to see lots more EAs with sort of question marks on them where their terms are just incapable of easy application. So I think that's another, would you agree, Mitch, another area to...
Totally agree.
Fantastic. So look, they're the risks. I think a good reason to spend a bit more time looking at your exposures in this space than may have been happening in the past. That leads us to part 2, Mitch. Now, what's caused this problem? Why are some enterprise agreements saddling employers with such a large non-compliance risk?
Look, many of these things we've already touched on in the introduction, Rowan, but experience tells us that underpayments can stem from the complexity and the ambiguity in the terms of an enterprise agreement. Examples that immediately spring to mind are those shift work entitlements, grandfathered terms and conditions, which often lead to different entitlements applying in parallel to same cohort of employee, albeit distinguished by when those employees commence their employment most frequently. What entitlements constitute ordinary time earnings for the purposes of superannuation, including whether an annual leave loading is linked to a loss of shift penalties during the ordinary hours of work or to overtime, for example. The interaction of casual loadings with ordinary and overtime rates of pay. Another examples that I've thought of in preparation for today, Rowan, is generally expressed coverage clauses of enterprise agreements that could, on one reading, be read to cover a wide cohort of employees and on another a more narrow cohort of employees. The other is very generally expressed or very complex expressed classification structures in enterprise agreements, which, to be fair, are often unintelligible to the lay reader and require a level of specialist expertise about the actual work that's being
sometimes
conducted.
Unintelligible to the experts as well, Mitch.
That's right. Experience also tells us that employers are often met with suspicion or resistance from union bargaining representatives when they wish to address the ambiguity and the complexity in their enterprise agreements during bargaining. This often comes at the back end of bargaining and is ultimately put on the back burner or abandoned to avoid putting the in-principle agreement that's been reached with bargaining representatives.
Well, we should come back to that point, I think, when we get to part 3, how do we actually achieve some positive change in this space. But I think it is important to acknowledge the difficulty here. I mean, the source of the problem in many cases is the fact that we're dealing with instruments, as you said, Mitch, that were made in the 90s, often actually founded upon words that were derived from instruments that preceded even that, consent awards and the like. And they're essentially terms that have just been added to and added to over the years. Often built, it's the metaphorical house of cards really, built on unstable foundations and then just tacked onto as time goes on, because it's all too hard for the bargaining participants to actually address some of the uncertainties that are built into those clauses that have sat there for, in some cases, decades. So we certainly don't intend to make light of the problem. These are difficult issues, but it's not uncommon to see, 50-page, 100-page instruments. I mean, that alone, even independent of the interpretation ambiguity issue, even just pure length is a risk in itself. I mean, the more prescription you have, the higher the chances are of non-compliance or missing something. And that sort of plays into the point we were making earlier about how much time is being invested in having to actually review these instruments to manage your day-to-day operations of a business. So, but given the serious consequences for employers, Mitch, I mean, you've got all the penalties that you referred to. I think it's only fair that employers are given a fighting chance at compliance, and only fair that they have instruments that are reasonably capable of being understood and then applied. And I think the counter to that, of course, is that it's only fair that unions and employees, I think, provide an element of support to employers to help negotiate instruments that give them a fair chance of compliance. Ultimately, it's the employer that's saddled with all the risk here. I mean, all the liabilities and penalty provisions you referred to, I mean, that's all on the employer. So I think what we really need to see going forward is a bit of help on the union side and the employee side to actually face into some of these issues, the complex, unclear, unnecessarily prescriptive conditions that put the employer at risk of non-compliance. Which is a very handy segue, Mitch, to how do we fix all of this? How do we incentivise unions and employees to actually negotiate clear conditions as part of their EAs, particularly where these unclear provisions have perhaps sat there for decades?
Look, I think, Rowan, the starting point, given we are talking about using enterprise bargaining as the vehicle for achieving clear and unambiguous terms, is that it's always important to be clear on your objectives prior to the commencement of enterprise bargaining. And in many respects, pay compliance is not static, but is instead an ongoing process of due diligence and continuous improvement. Underpayment risks are often ones which cannot be completely eliminated, usually owing to the limitations of payroll and time and attendance systems, and the need for human actors to apply exemptions in certain circumstances. Employers should therefore be taking a risk-based approach to the development of its claims, which includes developing bargaining claims directed at minimising the risk of underpayments.
So your point being that, look, there's no point striving for perfection because that's in a sense impossible. Let's focus in on what are the provisions causing the most risk and focus on addressing those.
That's right.
Yeah.
So, to achieve this end, employers should be reviewing and cataloguing the complexity and ambiguity in their enterprise agreements and develop their bargaining claims accordingly. And taking that risk-based approach, you would prioritise those claims in bargaining like you would any other claim. The other important point to make is that employers should be checking with their payroll specialists before signing off on any claims. They'll have some great insights on the problems and how neatly the conditions align with the inherent constraints of payroll and time and attendance systems that are used by that employer.
It's a great point. I mean, there's no point doing a deal in bargaining, getting the agreement over the line, getting it approved by the Commission, running it off to payroll to implement, and then working out actually our systems can't cope with that weird and wonderful condition that you've agreed to. That's a bit of a disaster. So that's a great call out, Mitch.
So, once your claims are set and prioritised and there's a clear understanding of what you're pushing for and why it's important, The next issue is, how do you encourage unions and employees to actually engage with those claims? As you pointed out on previous episodes of the podcast, Rowan, employee bargaining representatives wield significant power under the Fair Work Act, particularly in the post-secure job, better pay and closing loopholes world. For example, they can unilaterally compel an employer to bargain where no more than 5 years have passed since the current enterprise agreement passed its nominal expiry date, and the proposed agreement will cover the same or substantially the same group of employees. They can reach agreement with other bargaining representatives on agreed terms for inclusion in an intractable bargaining workplace determination. And this is all without the accountability of having to demonstrate majority support to bargain, or that a majority of employees agree with the terms to be included in a workplace instrument that will ultimately apply to their employment.
It's a lot of power when they also don't really have a great deal amount of skin in the game in terms of the compliance aspects once the EA is made. So how do we bring that into play in the bargaining, Mitch?
Look, in the wise and oft-cited words of Stan Lee's Spider-Man, with great power comes great responsibility. So employers should be taking the opportunity to remind employee bargaining representatives about their responsibility when it comes to setting the terms and conditions of the employees whose interests they represent. Creating an evidentiary trail in this regard is important, because it could be deployed as evidence that unions who apply for a protected action ballot order, for example, or who are purporting to take protected industrial action and not genuinely trying to reach agreement, to defeat the PARBO application or to remove the cloak of protection of industrial action. However, I have to acknowledge here that the threshold for meeting the test of genuinely trying to reach agreement is quite a low one. And if a bargaining representative engages to say that they don't agree with something, and the reasons for that, you're probably meeting that threshold on genuinely trying to reach agreement. But nevertheless, it's also important to acknowledge that bargaining representatives are bound by the Fair Work Act's good faith bargaining obligations. These include attending and participating in meetings at reasonable times, disclosing relevant information other than commercially sensitive or confidential information in a timely manner, responding to proposals made by other bargaining representatives for the agreement in a timely manner, giving genuine consideration to the proposals of other bargaining representatives for the agreement, and giving reasons for the bargaining representative's response to those proposals. Refraining from capricious and unfair conduct that undermines freedom of association or collective bargaining, and recognising and bargaining with other bargaining representatives for the agreement. And it's important to acknowledge at this point that these good faith bargaining obligations are no less applicable to employee bargaining representatives where an employer proposes changes to address complexity or ambiguity in the extant terms of an enterprise agreement. Bargaining representatives have an obligation to engage with these issues.
Yeah, and I think that's a point that's actually often lost, particularly on employers, Mitch. I mean, those obligations that you ran through, they have a lot of power in this context because it requires unions to actually engage with the problem that you're trying to fix. And it's important that employers don't let employees get away with not engaging with those very sensible proposals that are being put forward to simplify, shorten and clarify enterprise agreements, because there is power there to do something about it. I mean, it's particularly important that I think employers are transparent about what they're trying to do, because once you explain it, once you've sort of run your risk-based approach, Mitchell, and you've identified your top 4 exposures, clauses that just don't make sense, you say to the union, look, this is what we all know that they mean. It's not really what they say. We want to clarify them just for simplification purposes. If you get pushback, well, the question is why? Why, union, are you pushing back on this claim? It's always how we've applied it. We're just simply clarifying that. What are you concerned about? Let's talk about your concerns, table them. We might be able to address them. And the good faith bargaining requirements enable employers to actually compel unions to engage in that process. And it often makes me think about, I know this is one that we talk about often, Mitch, but the incorporation of awards. Ooh. I mean, you love this issue. EAs that incorporate sometimes several modern awards. sometimes even historical awards. And they say that, well, the awards are incorporated except to the extent that the enterprise agreement deals with the issue. In that case, the enterprise agreement prevails. Now, how often do the bargaining participants actually understand what that clause does? What are the actual terms? Requires you to embark upon this forensic comparison between an award and an agreement. Now, I've had cases, Mitch, I think you have as well, where the employers actually tried to remove that incorporation because it's unclear what it does. As far as the employer's aware, it actually does nothing because the agreement comprehensively deals with every condition that's contained in the award. And yet, despite that very well-reasoned response to removing the condition, union says no. Question is why? Why? I mean, the answer from the union's perspective is, well, we're worried about what that does. There might be unintended consequences. We don't want to lose conditions. Well, good faith bargaining requirements tell us that isn't good enough. You can't just say, well, we're worried about this unidentified loss of conditions that might somehow eventuate. It requires them to do the work, do the analysis and tell us, what do you say is being lost if we remove that term from the agreement? And if you can't tell us, well, the answer should be, let's get rid of it. But I think you're right to call out the good faith bargaining provisions, Mitch, because they've got a lot of power, a lot of work to do in this context.
Yep. The other point that I wanted to make here, Rowan, was the power of explanatory materials for the purpose of explaining the terms of a proposed enterprise agreement and their effect to employees. So whether you get alignment with the union bargaining representatives or not, there's still an opportunity to reduce risk through some of the information that gets circulated to employees ahead of the vote for a proposed enterprise agreement. So it's important for where there is ambiguity or there is some uncertainty to give some special attention to building in more detailed explanations into explanatory material relevant to the interpretation. It's great evidence of mutually known facts of the parties are ahead of a vote, and it's a way of informing employees about the terms and not just explaining these things to union bargaining representatives in the context of bargaining. They explain the context, why a clause is expressed in a particular way, what it's intended to do, what its effect is, and precisely why the Fair Work Act, and it's precisely why the Fair Work Act has these obligations in it.
Yeah, I think you're right. It's another area that there's, I think, room for improvement on the employer side because it is one instrument, or I think you used the word artefact before, that is going to be admissible in any dispute on the terms. It's information that was presented to employees by the employer ahead of the vote that can be taken into account in interpreting the agreement. Now, a lot of opportunity there. Like if you, despite our best efforts using good faith bargaining provisions, justifying and explaining your position, you still might not be able to get employees and union over the line on these changes. But there's still opportunity to explain what you say as the employer the agreement means or is intended to mean as part of that explanatory material. And if it's voted up, well, that will carry a lot of weight. So yeah, it's worth looking at those things as well, Mitch. But that sort of brings us to, let's say it's actually not possible to convince employees and unions to play ball on this in bargaining. Let's say, despite having great reasoned, justified position to clarify a particular clause, union employees might say, well, I agree with the intent to clarify. I think it should be clarified in a different way. I think it should provide for this condition rather than the one that you're pressing for. What are the options in that scenario, Mitch?
Look, in the situation where you don't reach agreement with bargaining representatives about particular terms and you've possibly had an unsuccessful vote of employees to make the agreement, this situation could lead employers down the path of the Fair Work, towards the Fair Work Commission making the intractable bargaining declaration and ultimately towards the Commission making intractable bargaining workplace determination, where the Commission will arbitrate the terms that were not agreed by the bargaining representatives during bargaining. This will inevitably lead to a loss of control because the parties are putting themselves in the hand of the Commission to determine the terms and conditions of employment that will apply under that instrument. This is precisely why it's important to invest in the explanation and justification of the need for simplification and clarity during bargaining and beyond that we discussed earlier. And ideally, employees will agree with the employer's proposal and will vote to make an enterprise agreement, and you don't end up in this situation. Alternatively, the explanation and justification will assist employers if they are ultimately required to convince the Fair Work Commission of the merits as part of an intractable bargaining workplace determination proceeding.
Yeah, so ideally you get it voted up, that's obviously plan A. But if you end up in intractable bargaining and having the agreement arbitrated, Fair Work Commission is going to be on board with the objective of ending up with an instrument that is as brief as possible, as clear as possible. You're not going to get any pushback on that front. The only issue that remains is, well, in clarifying a term, how will it be clarified? What words are used, and does that deliver perhaps an extra condition in favour of the employer or the employee? That's really the issue. So that's the exposure, I guess you refer to, the loss of control. But it's very clear the Commission will be on board with the broader objective. And if the condition is material enough, if the risk is material enough, if you've sort of quantified the actual cost of the absence of clarification, then there may well be cases that warrant actually taking the agreement into intractable bargaining to achieve clarity on certain conditions. So it's certainly an option. But it won't be for everyone, Mitch. I mean, there'll be plenty of employers out there that don't want to invest in that process or won't be in a position to sustain industrial action, noting that you've got to wait until 9 months post normal expiry at least to go down that path. What options are available for those employers?
Look, there's a couple of options for employers here. The first is applying to the Federal Court for a declaration about the interpretation of a particular term of the enterprise agreement. Now, that's it's a rarely used mechanism in my experience, and it's also more of a time-consuming and resource-intensive process than most employers are willing to invest in.
Often one you do outside of bargaining, I guess,
yes,
rather than during it. Yeah.
That's right. The other could be an application to the Commission to vary the enterprise agreement due to ambiguity or uncertainty. However, recent case authorities have demonstrated a general unwillingness of the Commission to rewrite the agreement to install something that was not inherent to the agreement when it's made and where there was no common intention supportive of the proposed variation. Now, that was demonstrated in the 2023 first instance decision of the Fair Work Commission and on appeal to a full bench in the Monash University cases. The other and third option could be putting the proposed variation to employees to vote on.
During the term of
during the normal term of the agreement. Now, the advantage of this, of course, is that it's all post-bargaining and protected industrial action is not a risk. However, it is a mechanism where you've got to have employees agree to the change and for it to be made and approved by the Fair Work Commission in much the same way as making an enterprise agreement in the first instance.
Sometimes a better environment, though, to achieve this type of change. A lot of the heat's taken out of it. It's sort of calm. There's not a great deal of downside to either party. Everyone's got control.
That's right. And it's often an opportunity to sort of narrow the issues that will be in play during the vote, whereas...
Next bargaining round, yeah.
That's right.
Yeah, that's well put. Any others, Mitch? I think there's one more I'd probably add to that. This is more an issue to think about during bargaining, but the concept of a reserved matters arbitration. So you might not be prepared to take the bargaining round into intractable bargaining. That might be something that's relatively unattractive for various reasons. But what could be done is you might be left with one or two outstanding claims that you just can't reach agreement on. You've agreed to everything else. These outstanding claims might relate to your objective to simplify or clarify the agreement. What you could do is agree with the union and employees that you'll put an EA to vote that expressly sets out that these two or three outstanding issues will be determined by the Commission post-commencement of the agreement through use of the dispute settlement procedure. That's actually possible with some careful drafting by setting out the parameters of the arbitration that the Commission would then undertake post-commencement of the agreement. We've seen examples of this and it being used to great effect to actually reach an end to the bargaining process and deal with these outstanding issues during the life of the next EA. Now, to your previous point, Mitch, obviously that involves handing over some control to the Fair Work Commission. You won't know with certainty which way the Commission will land as to how it interprets the relevant condition that you want some clarity on. But it's another option that's available to consider on top of this very large suite of options that are available to employers to address these issues.
It's a particularly helpful option, Rowan, if the employer needs a circuit breaker to bring enterprise bargaining to an end, to make an enterprise agreement, have an interim enterprise agreement, and then deal with this as an ancillary issue to the broader making of the enterprise agreement.
Yeah, agree. But what we've gone through today, though, Mitch, is a bunch of examples of things that employers can do during bargaining to perhaps pressure unions and employees to deliver some increased simplicity and certainty in enterprise agreements, but also a suite of measures that are available outside of the bargaining process to achieve some greater clarity and simplicity as well. The important thing is to be aware of all of those options as a starting point, but then factor them in to your bargaining and broader industrial relations strategy so that it's clear which ones are you going to look at pursuing, when and how. That's really the important thing. So Mitch, thanks for your insights on this important topic. Hopefully less furrowed brows into the future as we start to clarify some of these instruments. But just to recap, I think I'd boil down today's episode into essentially 5 tips for employers. The first is to look at your enterprise agreement with fresh eyes, given the heightened risk to employers of non-compliance when it comes to unclear, uncertain, ambiguous enterprise agreements, particularly given the reputational consequences that can flow from getting it wrong. The upside in securing simpler, clearer, shorter conditions is material and can be quantified. The second tip is to get alignment within your organisation that this is important. Now, we spoke at the start of the session about quantifying those benefits, the management and HR time involved in actually working out what your obligations are, the cost of getting lawyers involved, the cost of disputes, the risk of penalties and compensation, etc., etc. These things can be quantified, and in many cases they'll be material, and it's just a case of using that data to get alignment within your organisation that these things are important, and at least some of them should be pursued in an outside bargaining to get that clarity. Third, make it a priority in bargaining. So you mentioned, Mitch, often there's a claim for simplification or modernisation, but it gets jettisoned at the last minute as the thing to drop in order to get a deal. There will be many employers where it's too important to do that. Now is the time to actually keep that claim on the table. How do we do that? Well, by being transparent about it, about the need for it, why it's necessary, the fact that the employer is then on the hook potentially in the event of unclear agreement terms, on the hook for non-compliance, and the expectation that employers have of employees and unions actually helping them deliver an agreement that gives them a fair chance at complying with its terms. The fourth tip is to improve your chances of avoiding adverse findings on interpretation by bolstering what goes into your explanatory material that is given to employees ahead of a vote. It's a great opportunity to explain the employer's perspective and what the agreement does, what it means, its effect on employees. That material will be admissible in the event of any dispute on its terms. And then finally, know and have a look at all the options that you have in achieving clarity on enterprise agreement terms. As we mentioned, Mitch, some are for during bargaining, some are available outside of bargaining, but there are many avenues available and some in a relatively low risk environment post the making of an agreement. So know what they are, plan for them, factor them into your strategy. As always, we'd love to hear feedback on Inside IR, so please comment, direct message, or send an email to insideir@hsf.com. And don't forget to tell your HR and safety colleagues of the impending release of our new podcast series, Inside Safety and Inside Employment. Otherwise, we look forward to you joining us on the next episode of Inside IR.